Hello and welcome to Judiciary Academy's YouTube channel. In this video, we are going to discuss an important case law, that is Vinod Dua versus Union of India. So if you're preparing for CLAT PG 2023 examination, do check out our other videos in this series as well, where we discuss in brief all the important judgments for CLAT PG examination. So let's start with this case. It's a 2021 judgment in a two-judge bench of the Supreme Court. The Supreme Court was hearing an important issue filed by Mr. Dua, who is a renowned journalist, with respect to some FIRs which were filed against him. So let's start the discussion on this case. We will talk about briefly the facts of the case, the issues involved, the legal provisions involved, and ultimately what was the analysis of the court. So before we start with the analysis of the judgment, it's important to know some brief facts about the case. So Mr. Vinod Dua, who is a renowned journalist, he made a talk show, and in that talk show, in one of the episodes, he was talking about the handling of the COVID pandemic. So against some of the statements that he made in this particular talk show, an FIR was registered against him in some police station in Himachal Pradesh under sections 124A, 505, 501 and 268 of IPC. So Mr. Dua approached the Supreme Court under Article 32 for quashing of all these FIRs against him, and he was also seeking directions from the Supreme Court for protection of journalists who have a standing of 10 plus years. So in this background, the two issues that were framed by the court were, firstly, whether the FIRs which are filed against Mr. Dua, should they be quashed by the Supreme Court under the exercise of the writ jurisdiction of the court, and secondly, whether any guidelines or directions have to be issued for protection of journalists who have a standing of 10 plus years. So the two important acts that we need to know is some provisions of the IPC, particularly provisions relating to sedition, that is section 124A, and of course freedom of speech and expression under Article 19(1)A, and the restrictions imposed on it under Article 19(2). Further, Article 32 in itself was also under discussion because the issue of maintainability was also raised by the respondent. Now coming to the main findings of the case. So the court discussed the issue under four different heads. First, they were talking about the maintainability of the petition, whether Article 32 allows them to entertain a petition for quashing of FIRs or not. Then they talked about the offense of sedition. Thirdly, they talked about whether in this case any of the alleged offences are made out or not. And lastly, they dealt with the issue of whether the court is whether the court has sufficient reason to issue guidelines in the present case. So on the issue of maintainability of writ petition, the court cited a few important judgments such as the Arnav Goswami case and a few other important judgments under Article 32, and the court held that petition for quashing criminal cases is indeed maintainable under Article 32. So it is not necessary to relegate the parties to seek an alternate remedy under Article 226 if a clear breach of any fundamental right is alleged. Then coming to the issue of sedition, the court relied on the landmark case of Kedarnath Singh versus State of Bihar, in which a constitutional bench has upheld the constitutional validity of Section 124A, but they have put a condition that only when there is actual violence or incitement to violence, only then the offence of 124A can be attracted. The court also relied on a few Privy Council judgments and the federal court judgment, and they relied on the findings of Niharendu Dutt Majumdar in the federal court case while tracing the history of sedition law. Then the court also briefly discussed the issue of freedom of press under Article 19(1)A and 19(2). They also discussed the meaning of public order under Article 19(2), as was added later on by an amendment. Then coming to the particular facts of this case, the court held that the ingredients of Section 124A IPC are not made out in the statements by Mr. Dua, because what he said comes within the permissible limits of the Kedarnath Singh judgment. The court also held that all the other offences are also not made out, and hence the court ordered quashing of FIR against Mr. Dua. Now coming to the last important issue, that whether directions or guidelines can be issued for protection of journalists who have a 10 plus years of standing or not. The court held that putting a condition of preliminary inquiry by a committee before registration of FIR will be in violation of the legislative scheme, and even in cases where court has issued such guidelines in medical negligence cases, it was only done because the scheme of IPC protects medical professionals under its general defenses. So the court refused to interfere in the realm of the legislature to actually give any guidelines of preliminary inquiry before filing of FIRs against journalists. So the final decision was that the FIR against Mr. Dua was quashed and the plea to issue directions of protection of journalists of 10 years standing was rejected. Now, the case assumes importance because there have been further developments on the issue of sedition, which are extremely important for CLAT PG examination. In May 2022, a 3-judge bench of the Supreme Court in the SG Wombat Kere versus Union of India case has put Section 124A into abeyance till the re-examination of the provision is done by the government. So this brings us to the end of our video. If you like this video, please like and share and subscribe to our YouTube channel.